Welcome to the Cook Group's podcast, What's Cooking in Litigation, with your host, Brian Wacker. In each episode, you'll meet industry leaders, innovators, and educators in litigation. We'll discuss the latest advancements, efficient practices, and strategic updates. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, cookgrouplegal.com. Now here's the host of What's Cooking in Litigation, Brian Wacker.
Hello, and welcome back to What's Cooking in Litigation. I am your host, Brian Wacker, and look, Meredith, you're back.
I'm back. I'm ready to go. How are you today?
You just had so much fun the last couple of weeks, and I know you were begging to get back on the show, so it's so glad to have you back.
I'm thrilled to be back. Thanks for having me.
Yes, we the last few weeks, last few episodes, as you know, Meredith, we've been sort of making the rounds, talking to different folks in the office in different parts of the country. And we're starting to shift gears a bit on the podcast to start talking about a bit more of the subject matter of what we do, and diving into a little more substance of sort of legal updates and sort of things that viewers and listeners can kind of get some usefulness out of going forward. So on that note, I do have a bit of a presentation I put together on my own here on labor and employment law, an area that I've got some what I would call expertise in. So I really do appreciate you maybe helping lead a discussion with me on that, and we'll get some slides up in a few minutes to walk through if that works.
Yeah, if you don't mind, before we get into all of that, can we talk a little bit about your background? Tell us a little bit about law school and how you got into this type of litigation.
Sure. Yeah. So like you, I've been an attorney now for about 15 or 16 years. I've been practicing in litigation my entire career. As you'll see from the monument national park behind me, the St. Louis Gateway Arch. I'm here located in St. Louis. But as you know, being from Chicago, being a St. Louis attorney really does require you to practice in a couple states, both here in Missouri and across the river in Illinois, which is why, the sort of the part of the subject matter we're here to talk about today, labor and employment law, is really such a fascinating, or I don't even know what the right word is, but it's an interesting part of my career because there's a real dichotomy between what law governs employers and their relationships with employees here in St. Louis and what law governs it a mile that way across the river. And so, yeah, in a lot of ways, I worked in a lot of different areas of litigation going back to my days as a lowly associate, but in recent years, I really have kind of zeroed in on a few areas, especially what I call labor and employment, employer side labor and employment law.
Sure. And you just recently joined not recently, it's been a couple of years now, but you joined the Cook Group in the last 4 years, I think it is, 5 years. Tell us a little bit about your decision to come to the Cook Group.
Sure. Yeah. So like you said, I joined in end of 2021. So I've been here about 3.5 years now. And, I'd been working for a firm based in Chicago, of all things, that about 250 attorneys or so. And with our St. Louis office, I did great there. I had a lot of great people I worked with. But I felt sort of an urge to get back to a firm that was a little more that I had a little more sort of identity with, and I felt a little more connected with. And so getting to a firm the size and with the relative sort of youth and energy of the Cook Group was sort of a no-brainer for me at that point, especially with all the opportunities the firm really provides and sort of our sort of national reach as opposed to the regional reach that my last firm had. So yeah, I've been here for 3 some odd years, helping Joe Hargraves run the St. Louis office, and really I do like what I like most, and I don't say this because you're on the call, but we have such a great dynamic with all the different offices in our firm, right? Mm-hmm. So we work hand in hand, we work together. There's not sort of these guys do this, those guys do that type of mentality. It really is sort of a a collection of great, young, aggressive, impressive attorneys doing good work in very tough circumstances in some very tough jurisdictions. And who wouldn't want to do that?
Who wouldn't want to do that? Yeah, absolutely. Yeah. Well, so that's our employer, but let's talk a little bit about employment law.
Wow, what a great segue.
What a great segue into it. You're in two of the hottest jurisdictions that I think there might be with some developing law under employment law. So why don't you tell us a little bit about that and some of the legal hurdles that you're seeing and liabilities for employers that we've kind of seen new trends in?
Sure. Yeah. So as I was saying before, we have sort of a dichotomy here in Missouri. If you were to say, where do you like defending employers most in employer litigation? I mean, I like defending them more in Missouri because the battlefield is a little more even, right? There's the laws aren't quite stacked quite so much against you as they are perhaps in Illinois. But yeah, in Illinois, there's just a constant stream of new law, new provisions, new obligations that are being put onto employers, specifically with respect to that sort of, what they're required to do with respect to employees, not only when they're employed by them, but even after post employment obligations. And so the law is really set up in a way to where if you're not sort of up to speed and not knowing what those burdens are and those obligations are, you could run into some trouble. And so what I've sort of put together here, and Joyce, if you're in the background, if you can sort of, wow, look at this production value, unbelievable. So what I've sort of put together here is a quick slideshow of some updates to employer side law in Illinois that I think, as we go through them, that any employer, whether you have 1 or 1,000 employees, would be well served in sort of just getting a feel for these things and making sure that your processes, your procedures, your handbooks are up to speed to avoid some of these legal hurdles. And again, some of these are smaller sort of nit things on the administrative side, but as you'll see, Meredith, on some of these with the potential for litigation, I think they could cause some real problems for employers if they're not careful. So why don't we go ahead and dive into that? I've put together sort of an overview here of what those new laws are, and again, on each slide, they all sort of go into effect or went into effect early this year. Some of them have tails on them where other obligations will be imposed later on. But you'll see that with all these updates, the folks in Springfield were pretty busy last year. As an election year, they typically are. And so we'll walk through a few of these administrative statutes, some of the more litigious statutes like the Human Rights Act, and then just kind of talk about what it is we should be doing to kind of keep up to speed. So why don't we dive in?
Let's dive in. I have a quick question for you. As an employer, how would an employer know about this information in addition to, of course, attending this great seminar? How would they get notification of this?
Yeah. So, where of all things, where I get a lot of my, sort of alerts and things is the Department of Labor, right? And so in any one of these points of litigation, or legislation rather, what happens is you've got a statute in place, and then it requires the administrative agencies to put out some regulations that sort of interpret or say how they're going to enforce what the statute is. And then they all invariably will put out guidance, right? They'll say, here's some FAQ, here's some sort of, best practices. A lot of them will, a lot of these things, a lot of these statutes, you may remember this from maybe when you worked when you had your high school and college summer jobs. They require a lot of these posters to be put up. The Illinois employment poster is like the size of a door these days.
It's huge. It's huge.
There's so many things, and I mean it keeps expanding. So in addition to finding good resources online, whether it's podcasts or blogs or what have you, go into the horse's mouth, the Department of Labor, and actually seeing what it is they say and not what some blowhard attorneys say what it means. It says Department of Labor is usually the best best place for it. So that's where I usually go first, and then and kind of expand from there.
Thank you so much. Yeah, I'm going to tell us a little bit about this Illinois Personnel Record Review Act.
Well, so this is one of those acts that, again, it may not seem like much, but it does have some requirements that, oftentimes when I have an employer come to me and say, hey, we just got rid of an employee, we think there might be an issue. I say, why do you think that? It's like, well, we just got a request for our employee records, right? And so that's usually because they're trying to dig in to figure out, is there some substance to a potential claim based on me being fired or being demoted or what have you. And so what the legislature has done is sort of streamlined and made an additional obligation on these employers about what it is that employers have to provide to employees, current and former employees, when they make requests. And so, these obligations have always been there, but in 2025 now, in addition to employment decision records, like the employee file on why you were fired or why you did, why an employer did XYZ. Now there's additional requirements that, to the extent there were any employment contracts, handbooks, versions of handbooks and policies that were in place at different times while the person was employed. All of those things now are subject to this personnel record review and request process. And so you'll see, there's a process in place of it has to be in writing and things that an employer has to do in response and their timeline to respond. And so really in terms of what is new, you got to keep and you got to provide more records than you otherwise used to have. So again, most employers are aware of this obligation. Now it's just been expanded, which I think is part of the sort of the greater trend in Illinois.
Is there a mandatory amount of time that a company should keep those records?
So yes. So in terms of most employers will say, or employment attorneys will say, keep those records for a period of 5 years, right? Because that 5-year period is going to expand beyond what nearly all of the statutes require you to keep things. Mm-hmm. Now, again, under this, the next slide I've got here, the Wage Payment and Collection Act, there are now new requirements with respect to pay stubs, right? So a lot of employers now, maybe this one doesn't matter quite as much to the big employers because they've got ADP or they've got all these other folks who are doing all the managing of records for pay stubs on their own. But, this one does apply to pretty much all employers in Illinois. And so if you're a mom and pop, or if you're still cutting regular checks to your employees, you are now required to maintain pay stubs for all your employees, including those that you terminate, for a period of 3 years, right? And so in this sort of day when everybody tries to get rid of their boxes of documents and everything, unless you're digitizing everything, this is a fairly substantial burden on smaller employers now to say, hey, you got to keep, even if you fired somebody after they came in and they worked for 10 days and it didn't work out, you got to keep that pay stub now for 3 years. It seems like an annoyance, but it's a real thing. And again, it can cause you problems going forward if you don't.
Yep.
A couple of the things, and this is sort of where I think we get into where you and I would probably, our ears perk up a little more in the sort of the pay dirt of labor and employment litigation, are some new amendments to the Whistleblower Act and the Human Rights Act in Illinois that are really, I think that they can actually really, these could expand quite a bit of litigation for claims made by folks who have been terminated or feel like they've been retaliated against. So the first one is this Whistleblower Act. All right. So if we were to step back and say, what's the Whistleblower Act? The idea is just generally, look, you can't be retaliated against by an employer, whether it's termination or a change in your status as an employee, if you exercise or engage in certain protective activities, right? And so in a lot of times in the normal sort of understanding of that is, well, okay, I can't be retaliated against if I practice my religion or if I do a handful of other things that were statutorily defined as a protected activity. One of those activities had always been, look, you can't fire me or discharge me or change my terms of employment because I reported a crime, right? Can't have, or I reported something that was going on at my work that was in violation of law or public policy. And that's a good public policy, right? We don't want to stifle employees or individuals from doing that. But at the same time, this is over time. I've seen this in cases that I've had. This is a right that has sometimes been abused, right? It's a right where someone will say, well, I may not have reported a crime, but I thought it was a crime, or I believe because in my internet research, I decided that what I saw going on the accounting books of my small, and this is actually, I won't use any names, but this is a case I had a few years ago, administrative staff saw some things going on, emails between the doctor and her accountant, and said, wait a second, I don't understand this, but it sounds illegal to me. And so she started to make a big deal about things that she had no knowledge of, right? And she ultimately tried to cook up a claim for engaging in this protective activity of reporting what she thought was a crime when it really had there was nothing illegal going on. She just didn't understand it. And in fact, she was just cooking this up because she was about to be fired because she was a bad employer or a bad employee. And so what we've seen now is these new definitions are actually sort of codifying that. You'll see it says using or reporting information where we talk about having a, quote, reasonable cause to believe that the information discloses a violation of a law or regulation. I think that could be actually pretty tough to defend against, as you and I are probably thinking in terms of motions to dismiss and summary judgment. I see a lot of fact issues here. I see a lot of gray areas that I think this statute and this expanded definition of protected activity is really going to expand the litigation on whistleblower claims.
Yeah, that's interesting because reasonable cause can have a broad context under it. I was just generally looking up the definition of and having a fair and justifiable reason. Well, a lot of people can have a lot of justifications for doing things, so that will be interesting to see how that plays out.
Yeah, you wonder is it going to be determined on a subjective or an objective or a both level? And all I know is that when I started asking those questions, I just think that increases litigation costs. As you probably think the same thing. Speaking of increasing litigation costs, there's some other definitions here that I think are worth noting. Is the Whistleblower Act now applies to every single employer in Illinois. So Meredith, if you had a one-person shop and I was your single paralegal, you're an employer for me for purposes of this act, and I could report you at any given time, and you're subject to it. So.
Well, I'm not reportable, Brian. I am not reportable. I do not do reportable things.
I did forget about that. Yeah, that was not in the show notes. I forgot. I would have known that had I studied up. Yeah, so employer and employee, which is often a fairly litigated issue in some of these in some of these discrimination and employment statutes on a state and federal level. They've basically expanded both of these definitions to be as expansive as you can. I mean, employee is defined for part-time contract employees, independent contractors. It expands a lot of protection, gives a lot more protections to folks that weren't there beforehand. And so, it added a couple new remedies here, back pay and front pay. So if someone claims they were retaliated against and were fired, it's codifying a lot of these common law remedies that folks have been trying to get, saying that you can get liquidated damages, back pay, front pay, and in fact, the Attorney General can get involved in investigations on this. So these definitions are fairly substantial, and I think that especially with the Whistleblower Act, might have flown under the radar. An additional thing that I think a lot of employers, especially folks who are sort of they're getting their next step, and they're sort of starting to the businesses that are starting to expand. Small businesses, they've got a lot of trade secrets, right? They've got a lot of customer contacts. They've got a lot of confidential information. So what is one thing that employers like to do? They like to shove these non-compete and non-solicitation agreements under the nose of new employees. And this is a practice that's been going on for years all over the country. Well, Illinois, in addition to some other states, including California, are really pushing back on this. Now, Meredith, you may recall back a couple years ago, the Biden administration the Department of Labor had issued a new rule sort of frowning on all non-competes and trying to sort of, with rare exceptions, get rid of them completely. That's sort of been scaled back a bit, but with respect to state level in Illinois has really scaled back the enforceability and whether or not these agreements would even have any validity as a matter of law, regardless of the circumstances. And so you'll see that, they've got these escalating clauses to where non-competes can't be provided or required or signed or enforceable by anybody under these certain levels of salary. And the same thing with respect to non-solicitation. And so you're seeing again this sort of trend in Illinois of sort of employee friendly, sort of favoring the freedom of transfer of work and the marketplace of moving around, where these agreements, I think you're going to see a lot of employers starting to subject their non-competes and non-solicitation agreements to other state law, or trying to hire people in other states now because these agreements are going to be per se invalid. Mm-hmm. There's additional restrictions. It seems like every year they add in additional industries and areas of folks who can't be subject to non-competes. You and I both know as attorneys, we can't be. It's sort of as a matter of law, attorneys can't be really subject in very rare circumstances to non-competes. Again, one thing that they've added here is construction workers who are subject to collective bargaining agreements, as well as mental health providers for veterans and first responders, which again, it's a small thing, but if you've got them, it's good to know that they're now technically, invalid, and you're not going to be able to hold that out as anything over a former employee going forward.
You bring up a thing about obviously lawyers, and we have our conflicts, and we need to make sure that we check all of that stuff. But and I understand that the non-competes and how they're really trying to go against it. It still doesn't alleviate the just confidentiality portion of an employee to its employer, right? So there's nothing changed with regard to employees can't take client lists, they can't do that sort of thing in order to further their career at another position. Is that still right?
It's fact specific, but yeah, in many ways, there are still common law obligations that employees, especially employees with access to confidential information and client lists, they still do have common law obligations to their employer, like the duty of loyalty, the duty of in some cases with certain, folks of a high enough level, a fiduciary duty because you've been entrusted with certain confidential or proprietary information, that yes, there are those sort of obligations, but these statutory protections, or the protections rather for non-competes and non-solicitations, that folks tried to sort of get into an agreement, which, have all these really heavy enforcement mechanisms, heavy remedies. Oftentimes what you see in a non-compete, Meredith, is, if a former employee is found to be out there working for a competitor, brought some computer code over from one place to the next, they've got provisions in there that talk about the availability of an immediate permanent injunction, right? Mm-hmm. Saying that, the employer says this is of such a important nature that you agree at the time of signing this that I can run to the court and get an injunction against you. Mm. And they've got these attorney fee provisions. They've got all these other things that aren't really available just a common law on a claim like that. So while you're right, those obligations still exist. They're the enforcement mechanisms and the remedies you can get under a non-solicitation and non-competition agreement. Those are becoming harder and harder to hold up. And frankly, courts hate them. My experience, and again, I don't know every judge in every jurisdiction, but my experience around St. Louis, around Southern Illinois, in the federal courts, you got to have a pretty good reason to have one of these, and they're going to hold employers to a pretty high standard if they're trying to enforce them. One other thing courts hate are violations of human rights. Look at these segues.
Their segues are fantastic.
No, this is the other main area I did want to talk about. So the Human Rights Act, every state has its own version of the Human Rights Act. You have the Missouri Human Rights Act, the Illinois, the Ohio, et cetera, et cetera. And oftentimes, many of them have pretty substantial overlap with a federal statute, which a lot of us know about, called Title VII, right? And so the idea is that employers cannot take certain actions against employees based on what we call protected characteristics, right? You're part of some protected class, whether it's based on your gender or your sexuality, religion, race, creed, et cetera. And those definitions have been expanding over time, especially in Illinois. But what it does is it really does, Human Rights Act on a 10,000 foot level protects against discrimination, harassment, and retaliation based on those protected characteristics. And so employers can't take adverse employment actions against their employees if one of those characteristics is or a contributing factor to the decision to make an adverse employment action. And so what has in the past been sort of your standard list of things, which has been expanded over time to recently it includes, it's race, color, religion, sex, sexual harassment. Over time, it expanded to include your arrest record. That was something more recently that was put in there. But most recently in 2025, it adds in family responsibilities. And, setting his personal views aside, this is actually a pretty tough obligation for employers to have to sort of navigate when they're trying to determine, all right, are we able to take an action against somebody who is just chronically absent or chronically late to work or is chronically behind on projects? And if the proffered reason for that is because of some sort of care or responsibility they have for a family member, well, in the past, that wasn't good enough to necessarily support an action under. It could have supported an action under the FMLA or different other statutes out there, but it wasn't always something that was protected by the Human Rights Act. And so now it is. And so you'll see employers can't take adverse employment actions or retaliate or discriminate against employers based on, and this is tough, actual or perceived provision of personal care for a family member. So if the care or the perceived care for a family member is even a contributing factor or substantial factor to why an employer makes a decision, it could really now affect and subject you to potential liability for violation of the Human Rights Act. And so employers can still enforce workplace rules they have. We all put in our rules about taking leave and scheduling and productivity and everything. But now you have this extra layer of we've got to kind of tiptoe around this if we decide we're going to take an action based on somebody being chronically late or absent, et cetera. So again, just expanding the playing field of what claims can be brought under the Human Rights Act. A couple other small ones that we can just kind of breeze through. I don't know a lot of people who are employing children for their labor these days, but Illinois did. I know that there's a trend in some other states, more probably conservative or red states, to allow additional or to sort of reduce the restrictions on children working. In Illinois, quite the opposite. They've repealed their prior child labor law, and they've now put into place new restrictions on when kids can work, how much they can work, what you need to do in order to get them to work, and what types of work they can do. So you'll see that during school sessions, they can't work more than 18 hours a week, 40 hours a week when school isn't in session. There are specific times. Now there's some exceptions for, working on the farm and things like that. Specific times that work is prohibited. And it also talks about just sort of special employment requirements you have to go through in terms of getting certificates and things like that to permit the child to be an employee. So again, there's some pretty stiff penalties for this. This is more on the criminal side than on a civil side. But if, for folks who are, employing, teenage interns or, camp counselors, kids who are, working for them over the summer, these are sort of things that you need to be on the lookout for and make sure that you're staying within the confines of what the new law requires. Again, more administrative here than anything else, but E-Verify, a lot of states in the United States allow you to use this E-Verify system to to confirm whether or not someone has proper work authorization to work here. Illinois actually said, wait a second, this is being abused, perhaps. Maybe E-Verify shouldn't be trusted quite as much as other places think. And so what they've said is now there are new limitations on the use of E-Verify. For instance, in Illinois, you can't use E-Verify to pre-screen in candidates anymore. This is tough to prove, but if it is, it could subject you to some real problems. And if you are using E-Verify, the person using it has to be trained with specific computer training, and you have to file attestations with the state saying that, yeah, Meredith Hudgens took training on E-Verify, and she knows how to use it, not how to use it within the confines of what Illinois law requires. And so, again, Illinois is joining California and some of the states, on the coast, where it's sort of this mini trend to start restricting the use of E-Verify as sort of a larger trend of sort of protecting employees' privacy and their employment rights. Here's one that I think this might be the last one we talk with any substance on, Meredith, and it might be something that you have interest in. You and I, we hire people, right? And we've got some, and it is not easy sometimes to hire people. The market is still very competitive and strong out there, and it's strong for, at least within the legal community. It's tough to find great candidates to fit what we're trying to do. Well, one of the things that employers over time have been able to use to their advantage is, well, we want to get you in, interview you, but we don't want to tell you exactly what it is we're offering quite yet, because we want to make you make the first demand of what your salary demand is and sort of tip the scales in our favor in terms of that salary negotiation, right? Well, if employers have more than 15 employees now in the state, employers, if you're making a job posting, as opposed to simply going out and recruiting or talking that way, but if you're making an actual job posting, you have to disclose a pay scale and benefits in the job posting itself. So it has to include a salary range, benefits description, bonuses, if they're applicable. All these things have to be disclosed, and they have to be part of what it is you're posting to the general public. Mm-hmm. And so, again, I'm not sure a ton of people know about this, because I see when we're looking for folks on message boards, I'm trying to see what the market looks like in terms of who's hiring. I'm not sure a lot of people know about this new obligation. And if they're reported, there are some significant fines here, right? So
the offenses are the penalties are interesting.
Yeah. So you get caught once or twice, okay, slap on the wrist, and hopefully they mean something. You do it 3 times, that's $10,000 for each job posting you do it for. That is a significant burden on folks that I'm not sure everyone is quite up to speed on yet. And so it will be interesting, I think, to see, will the Department of Labor or the Attorney General start to clamp down on this a bit? Maybe will they start investigating some of these, job posting boards? Because I think that there could be some real issues out there. And so a few of these other things here, I mean, it applies to remote positions. It applies to third-party job posting. So if you use ZipRecruiter or whoever it is to post something, they've got to comply with it too. It even applies to internal promotions, right? So if you're going to be looking around and you've got a bigger business, and you're saying, hey, we're going to look internally as well. If it's externally posted, you got to post it internally as well. So, it's a significant burden, and it kind of shifts the landscape of, what the negotiations for comp and benefits are going to be going forward. Finally, there's a new law called the Captive Audience Law, which I think is really just kind of almost duplicative of other laws. But what it does is creates the Worker Freedom of Speech Act, which basically says that employers can't be go around discharging or disciplining people for refusing to attend a meeting or participate in political or religious matters. Frankly, I think that's already covered by about 7 other statutes. But why have 7 protections when you can have 8? And so there is this additional new statute where employers can get sued for violations.
Illinois likes to keep it thorough.
Yeah, exactly. Right. Like why? It's like the lawyer's employment plan of 2025. Like, give us more opportunities to charge clients for being sued for these things. So anyway, so this all kind of gets to, sort of wrapping it up. I know I've been speaking a ton, but I mean, things are always changing. There's always changing in every state that you have employees in, but especially in Illinois, there are a lot of changes that are constantly happening. So one thing that I know that we've done on our end here, and I've been counseling a lot of my clients on, is updating your employee handbooks, making sure that your processes for record retention are now compliant with the minimum standards of the state, if not more. Making sure, again, job postings. One of the things that I can't stress enough that if you're putting a job posting out there, it stinks, but everyone has to do it, and there's substantial penalties in there if you haven't been complying. And then, really, one thing that you have to have a frank conversation with some of these clients on, Meredith, is they think they've got a lot of security and sort of support with these existing non-competition agreements that they've got in place with employees I hired 10 years ago, 12 years ago, whatever. They really have to go back and kind of review and assess, do these things really hold up to scrutiny at this point? The law's changed a lot, and is an Illinois court going to really hold one of these up if one of my key employees leaves and goes to work for the competitor down the street? So it's a very long-winded way of saying, talk to an attorney, talk to me, give me a call. But no, really, employers would be very well advised to get up to speed on these things, do some research, and then, if you do have concerns, get in touch with a good labor and employment attorney. Be penny wise on the front end instead of pound foolish on the back end when you haven't complied with one of these things. It sort of comes back to bite you in the end.
Thanks so much, Brian. That's a lot to get into, and so we appreciate you doing such a good job and making some bullet points on it. A lot of things to really get caught up on, and making sure that as an employer that you are readily updated on these things. So we really appreciate your time and your knowledge on that. Anything that you want to leave us with regard to just general employment law, even if it's not an update, but just something that they should consider doing?
Think twice, or what's the thing that my grandpa and my dad would tell me when they were trying to make me into a handyman and I had no skills. Measure twice and cut once. Think twice before you make decisions. There's a lot going on out there, and if it requires you to pay a little to an attorney to make sure you're on good footing when you make a big decision like disciplining someone, discharging, terminating, it makes a big difference when if you haven't done it, it's going to cost you a lot more on the back end. So, Joyce, with that, I think we can take the slides off the screen, and this is my opportunity to thank you, Meredith, for taking the time out today. I know that you are incredibly busy. I know that litigation season is hot summer here in St. Louis of trials and litigation, and up in Chicago as well. So I know you're very busy. I appreciate your time. And
thank you, Brian. It was really helpful. It was really good to hear about all of these things and kind of understand the changes in the lay of the land of where we're at. So Thank you for your time.
It's scary out there. So on that note, we appreciate everybody for tuning in. As always, if you've liked what you've heard, please like the video, like us on any of your podcast apps or websites, leave a review, or reach out to us. We'd be happy to talk to you about anything we've talked about within the podcast or any of our podcasts. So without further ado, appreciate your time, and we will see you next time on What's Cookin' in Litigation.
See you later, everyone.
You've been tuning in to the Cook Groups podcast, What's Cookin' in Litigation, with your host, Brian Wacker. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, cookgrouplegal.com. Thank you for sharing this show with others.